Hello and welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today's topic is very important for anyone who has made or plans to make a will. How can a will be cancelled, revoked, or modified legally? 1. Right to cancel a will. The testator, or the person who made the will, has the absolute right to revoke or modify their will at any time during their lifetime, as long as they are of sound mind and not under any undue influence. This right is fundamental and cannot be challenged by anyone, even beneficiaries. It means that the testator is always free to change their mind about who should inherit their property or how it should be distributed. This freedom helps to ensure that the will truly reflects the current wishes of the testator. 2. Methods of revocation. There are several ways a will can be revoked or cancelled legally. Making a new will. The most common method is to create a completely new will that explicitly revokes all previous wills. This is usually stated clearly in the new will with a clause such as, "This will supersedes and revokes all earlier wills made by me." Physical destruction of the old will. The testator can physically revoke a will by destroying the document. This can include burning, tearing, or otherwise mutilating the will with the intention to revoke it. It is important that the destruction is done by the testator themselves or by someone else at their direction. Express revocation in writing. The testator can also write an express statement revoking the will, for example, a signed declaration saying the will is cancelled. This revocation must be communicated clearly. 3. What is a codicil? A codicil is a legal document used to make small changes or additions to an existing will without rewriting the entire will. It allows the testator to update certain clauses or include new instructions without disturbing the rest of the will. Like a will, a codicil must also be signed by the testator and witnessed by two independent witnesses to be legally valid. For example, if you want to add a new beneficiary or change a share, a codicil is a convenient tool. 4. Revocation after registration. Even if a will has been registered with the sub-registrar office, the testator can still revoke or modify it anytime. Registration does not make a will permanent or unchangeable. The same rules apply. A new will or codicil that complies with legal formalities can override the earlier registered will. Hence, it is important that the latest will or codicil is the one kept safe and communicated to family members or executors. 5. Which will is valid? In case multiple wills exist, the latest will made by the testator before their death is considered the final and legally valid one. Courts will generally give effect to the most recent will, provided it meets all legal requirements. Therefore, it is crucial that every will or codicil clearly mentions the date and is properly signed and witnessed. To avoid confusion or disputes, it is also advisable to destroy or revoke earlier wills when making a new one. Summary. In summary, you have the full legal right to cancel, revoke, or modify your will at any time during your life, provided you have the mental capacity. You can do this by making a new will, physically destroying the old one, or adding a codicil for minor changes. Always ensure your latest will is properly dated, signed, and witnessed. This way, your final wishes will be clearly known and respected after your passing. Thanks for watching this video. If you found it informative, please like, subscribe, and comment your doubts or questions below. Jai Hind! Jai Bharat!